Hello, ladies and gentlemen, welcome to the Coin Lady channel. Judge Torres appears to have recognized the SEC's errors on several key claims in the SEC versus Ripple lawsuit well before Ripple's attorneys did. And this provides a substantial clue as to the judge's thinking and the likely outcome of this lawsuit. I respect the opinion of solicitor and XRP community member Bill Morgan, so I'll share his thoughts with you. Because most of us in the XRP community are complete morons, it's a blessing that we have so many brilliant legal minds among us. However, if you are not a solicitor, you will not be able to read between the lines, pick up on certain cues, or understand the way things are written from a legal standpoint. Given that Judge Torres may have been on Ripple's side, Frankie, before Ripple even made some key arguments, having a solicitor like Bill Morgan break down why he thinks it seems that way is certainly possible. I mean, he lays it all out here, and I'm going to tell you what I think about it. But before I go any further, let me make one thing crystal clear. I come from no financial or legal background. Neither legal nor financial counsel is being provided by me. And you should not make any financial decisions based on anything I write or say. Simply put, I'm a hobbyist who finds enjoyment in creating, sharing, and discussing videos on YouTube about various aspects of the cryptocurrency and blockchain industries. Is it possible that Judge Torres realized the SEC was wrong before we did? Here is the response of Bill Morgan, a solicitor. When arguing fair notice, what role does the blue sky problem play? To be honest, I didn't realize its significance to the fair notice defense until after I had assumed it only applied to the Howey analysis. However, Ripple fought the SEC's fair notice summary judgment motion. It is abundantly clear that the defense is arguing that Ripple's sales do not involve contracts and lack the necessary elements that define an investment contract. This is the screenshot he showed me. The relevant area is highlighted in yellow. And the text looks like this. Defendants' XRP transfers frequently lack the essential ingredients that define the legal term investment contract, and often occurred without any contracts at all. That way, no normal person would ever mistake them for investment contracts. Then, the words of Attorney Morgan, therefore, no reasonable person would mistake those Ripple sales for actual investment deals. Those crucial elements that Ripple noted in its summary judgment. Investors' post-sale obligations and counterclaims against the seller are addressed in the opposition brief. The Howey investors had this screenshot, which they shared with us. The relevant section is highlighted in yellow. And contracts are not even remotely relevant to this case. Rights and responsibilities after a sale has been made. So, folks, right off the bat it's obviously very different from what occurred in the SEC. The Supreme Court's decision in the famous v. W. J. Howey Company case from 1946. That's why I have faith that justice will be served even if we get a bad decision from Judge Torres, which I highly doubt will happen. But even if we do, and this case makes it to the Supreme Court, the SEC will be soundly defeated. Attorney Morgan promises to return the favor by knocking those bimbos back in the next and final Tuesday. In my opinion, Judge Torres handled this situation appropriately and promptly. Prior to Ripple's summary judgment motion, in which the blue sky issue was first raised. So, take a look at this, people. Now we're getting to the meat of the matter. In a nutshell, Ripple's position is that a contract between the seller and investors is required, regardless of whether the scheme complies with the contract's terms or not. Because XRP holders have no recourse under the law, the company claims they owe them nothing after the sale has been made. Judge Torres found the fair notice defense to be relevant when she denied the SEC's motion to strike it. The majority of XRP holders, according to Ripple's claims. And this is crucial. Try this out. The pertinent part is as follows. It claims it has no connection to the vast majority of XRP holders and has never sold XRP as an investment. So, at least we have that. Again, can you see how this is connected? Because, once more, I need to reread it to make sure the meaning is sinking in. Because, once again, the SEC wanted the fair notice defense out of their founders relevant, Attorney Morgan wrote Judge Torres when she made her decision to dismiss the SEC's motion to strike it out. The majority of XRP holders, according to Ripple's claims. The judge has thus confirmed that there is absolutely no connection between Ripple and the court. For the vast majority of XRP holders, this is the end of the story. This is of great importance now. Look at this, then. Solicitor Morgan will carry on. While the judge may have had no contractual relationship with XRP holders in mind, he or she clearly saw where Ripple was going with the investment contract argument and how it related to the fair notice defense. Do you finally get it? That right there is the crucial bit. This is the first time I've heard a solicitor explain it like this, and I couldn't be happier that he is. His explanation makes complete and total sense. Because there are so many of us, there are millions upon millions of almost 0%, so it's clear that Ripple's statements had no bearing on the vast majority of XRP holders. And so Attorney Morgan is saying what might have been going through the mind here, and if that's what was going through her mind before Ripple even made the argument, then there would be because, again, the theory being here from Attorney Morgan is what if she's thinking that means there's no contractual relationship because there's no contractual relationship, no post-sale obligations, and all that stuff. If that's the case, the SEC is completely wrong. If that is indeed what she is contemplating, it is significant. When everything finally collapses, which could happen any day now, that tells us something about the kind of rule she'll be imposing. It's possible that it will drop this month, but I can't say for sure. Let me just read the last sentence. Attorney Morgan says, to start the conversation flowing. Yes, that is the case. Now, no relationship with XRP holders is broadly expressed, but I suggest what the judge had in mind was no contractual relationship and understood where Ripple was going with the no investment contract argument and why it was relevant to the fair notice defense. Plus, it needs to be instructive. In ruling against the SEC's motion to strike down its fair notice defense, the judge emphasized the importance of providing clear notice. Then he displayed a screenshot with an arrow indicating its location. He then goes on to say more. As Morgan speculates, this ruling may explain Gensler's repeated assertions that all cryptocurrencies other than Bitcoin are securities. No. Case involving cryptography that occurred before the SEC was established. In transactions involving Ripple, the seller and buyer are not bound by any post-sale contractual obligations or rights of token holders against the seller. If Ripple is right under the law regarding the blue sky issue, then no earlier crypto case or SEC guidance has contradicted this position. To what extent did the SEC succeed in meeting the need for transparency? There is a mountain of evidence showing that it neither provided clarity nor considered XRP a security. Judge Torres' handling of the Doorbit challenge to Alan Schwartz's expert testimony demonstrates that she has a deep understanding of the issues at hand. Ripple has energized the conversation about after-sale duties and how they relate to the fair notice defense. And so I'll pause to note that many lawyers simply do not believe, for whatever reason, that on the district court level, where we're currently operating, you're going to have a judge that will look at the fact, the certain circumstance regarding the lack of post-sale obligations, this or that, to rule in such a way that it's going to be positive for Ripple here. However, Attorney Morgan has pointed out some evidence suggesting that this may be the case. Lawyer Morgan continues by pointing out that Alan Schwartz testified in his opinion that the contracts Ripple entered into lack post-sale obligations, in contrast to the Howey contracts. And he forwarded this screenshot with the following text. Contrary to the Howey contracts, he believes that none of the Ripple agreements bind the company to take any post-sale actions that might affect the value of XRP or return profits to any person, end quote. This is important for a number of reasons, not the least of which is that Judge Torres threw out the most crucial assertions from the SEC's expert witnesses, in regards to the expert witnesses and the Doorbit motions. Nevertheless, this fact supports the argument that Attorney Morgan is making. It's a pointer, a hint, that Judge Torres probably gets that post-sale obligations are huge in the law, but they don't apply here. This is something that is consistently brought up by the SEC's experts but not by Ripple's. Is that so? Certainly intriguing. Bill Morgan then claims that the judge has allowed this evidence to be presented. It's important to the fair notice defense, as I've already explained. At summary judgment, I do not believe the SEC will succeed on the fair notice defense. So, it's possible that this provides a glimpse into Judge Torres's mind. And I think we're going to find out pretty quickly. However, that is an intriguing viewpoint. No, I don't give out financial advice. Nothing I say or write should be used as a basis for making financial decisions. Please like and subscribe my channel if you enjoyed the video. See you in the next video. Bye.